Mr. Chavez, we are live. You may proceed.
Good. Good morning, folks. My name is Stephen Chavez. We're on the record. I'm the city's land use hearing officer for the city of Albuquerque. Today's date is August 27th, 2020. We are here on an appeal, AC-20-8, and this appeal is related to AC-20-6 and AC-19-18. As you know, we are still under public health orders with the state, and therefore we're having this hearing remotely. So as you know, there are basic rules for this hearing. To prevent possible background noise, you need to keep your audio muted unless you need to speak. If you need to speak, unmute your audio with the Zoom, not your computer. You may want to turn off your camera if things start to lag, because the camera, it turns out, will slow things down. So our host will be monitoring this hearing, and he will unmute your audios when you are about to speak, if he can anticipate that. This hearing is open to the public under the city's YouTube channel, and it is being viewed currently right now, I believe. And we are also recording this hearing by a certified court reporter. So let's make our appearances for the record. Mr. Chavez, the appellant, starting with you. Full name, sir?
Full name is Richard Chavez. I reside at 906 15th Street Northwest, Albuquerque, New Mexico, 87104.
Okay, I'm going to swear you in, sir. Please raise your right hand.
Okay.
Okay. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
Thank you so much. Now, next with the city of Albuquerque, who is going to speak first? Ms. Gould?
Yes.
Full name for the record?
Maggie Gould.
Let me swear you in. Can you please raise your right hand? Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
Yes, I do.
Wonderful. Mr. Biazar, do you intend to speak at this hearing?
Mr. Chavez, no, I don't.
Okay.
Matt Grosh will be speaking on behalf of the transportation section.
Okay, thank you so much. And I note that with the city attorney's office, Ms. Nicole Sanchez and Mr. Alan Varela are here in this hearing as well. Thank you folks for attending. Let's proceed. Are there any preliminary matters that we need to deal with?
Good morning, Mr. Chavez. This is Nicole Sanchez representing the City Development Review Board. We do not have any procedural matters this morning. Thank you.
Thank you. Mr. Richard Chavez, is there anything that we need to deal with?
Not that I know of.
Good, good, good. Okay, well, let's get started then. Mr. Chavez, you know the rules. You've been here before. Let's hear from you, sir. And I have read the entire record, by the way.
Thank you, sir. First of all, I want to acknowledge the positive within the planning department that I've had to deal with, because most of my experience has not been very positive. The people that I've been dealing with have been exemplary. They've been in their response, their timely response to me. They're willing to go out of their way to help me with this application process, because I've been, as new as I am to this process, there's a lot of questions I have. And so I just want to acknowledge that the administrative support staff of Alfredo, Annette, and Vanessa have been exemplary in their customer service. And the key there is customer service. They recognize me as a customer, and they treated me in that vein. Contrast that to the treatment by the professional staff. When I came to ask what it would take to do a lot line adjustment, from that point on, I was viewed as a developer, and I immediately became an adversary. As an adversary, staff had to maintain some level of advantage. How do you do that? You control all the information. In my case, I believe, and all applicants before me, were not given all the information for an application. Pertinent information was willfully withheld, and that being the Chapter 12 introduction to sidewalk ordinance, which provided 9 different exemptions that a person could apply for when applying for a variance. That versus the one criteria that I was initially given by staff and the DRB board. Even though I was not applying for a variance, The question has to be asked, if I had applied for variance, why would 9 key criteria be withheld from me versus the one exception I had to meet for them, the DR board, or any other applicant prior to me? You now see that Chapter 12 is part of the application process. As an applicant, I was very naive to the ambivalence staff has towards developers, in my opinion, because at one point in time, the traffic engineer referred to me as a developer before she caught herself. When I first approached the planning staff about a lot line adjustment, they stated that I had 2 options, that I could apply for a waiver and a variance. Each had a separate application fee. And what I didn't realize that both the waiver and the variance were using basically the same criteria, even though I paid for a different set of criteria and outcomes. This is where the confusion begins, because unknown to me, and apparently the planning staff, the city council had amended the sidewalk ordinance in May of 2019, which would have corrected the confusion I was dealing with and the confusion that I was dealing with. The planning staff or planning department failed to administratively incorporate those changes that the council approved until approximately January 7th, 2020, when I was to make my first appeal hearing. As of October 2019, the denial letter from the planning director, he was still using terms waiver and variance interchangeably. Planning staff states for the record that changes were insignificant, and apparently I did not need to know that the rules had been changed for my application. Staff did try to encourage and coerce me into apply for a variance without communicating that the waiver issue was no longer available to me. What I was told by staff that my waiver would not be approved. If changes were insignificant, why did staff, on 2 occasions, for the record, try and say that I submitted my application in July? In my opinion, it was to show that staff only took 6 months to administratively incorporate the changes City Council approved instead of the actual 8 months it took staff to address the changes in the ordinance. So it appears that I was misled intentionally or otherwise as to what I applied for, which was a sidewalk waiver. I want to reiterate for the record that I never applied for or requested a variance, as staff continues to state. You will not find any indication that I applied for a variance. I was directed by staff to check off the box for a variance on the application if I wanted to apply for a waiver. At no time did staff ever clarify, notify, or indicate that my waiver application was no longer valid. My argument is based on a very simple concept, common sense. Where does it make sense to create an island of sidewalk, as stated by EPC Commissioner, that creates more of a hazard for an individual in a wheelchair or a walker because they don't have safe egress off the sidewalk? The fact that almost 1 year later I'm still dealing with such a simple request goes to the problem. The problem is a poorly written ordinance. The lack of clarity in the ordinance for my application was validated by the arbitrary and false statements that staff has made over time. Staff has arbitrarily applied facts to justify their position and conveniently ignores those questions that are not convenient to answer. Example, that installing sidewalk would enhance the safety of pedestrians. I asked staff, enhance it from what to what? And staff has never answered that question. If anything, it makes it more dangerous for me as a property owner because the setbacks you are requiring has now made my house more accessible to home burglars. In what world does it make sense to end a sidewalk in front of my neighbor's 70-year-old elm tree? What do we know about elm trees and sidewalk and roots? My property line is 10 inches from the base of the elm tree, and my neighbor is not going to volunteer to put sidewalk in, period, much less a sidewalk that goes around the tree. What disabled individual in a wheelchair or walker is going to get on a sidewalk that leaves them 10 inches from an elm tree in order to exit the sidewalk? This does not include the fact that there will be a 2 to 3 inch deviation in the sidewalk surface to the dirt surface. I would like somebody please explain to me in what world this makes sense. Ask a person who is physically impaired why this becomes so dangerous to navigate a partial sidewalk installment. In addition to the deviations, ADA and OSHA stipulate any surface with deviation more than a half inch is a tripping hazard. So now I'm forced to run a person in a wheelchair into a tree with a gap of 10 inches to a dirt surface. Now the tripping hazard becomes a legal liability for every disabled person who cannot exit off the sidewalk and the person walking at night who can't see the difference in the deviation between the sidewalk and the dirt to sue me. Again, in what world does this make sense for the record? There is no such thing as, and I want to emphasize this, there is no such thing as a transition from sidewalk to the dirt surface. The sidewalk comes to an abrupt end, period. The statement by staff and FCC board members that you can do a transition is a false and misleading statement, and it's made in order to minimize the potential liability that a tripping hazard creates for a property owner. Based on 3 different sidewalk contractors I've spoken to, none of them agree that you can do a transition to a dirt surface from a sidewalk surface. I specifically would like to get an answer from staff today, for the record, as to how this could be safe for a person in a wheelchair, walker, or somebody walking late at night with no lighting. Because when I'm sued, the city's also going to be sued, and the comments from staff will be used as evidence that putting a tripping hazard was not my idea. Staff has conflated the pedestrian traffic along Mountain Road, which is a designated pedestrian and bicycle avenue, to say that my street is experiencing the same kind of pedestrian traffic. I'm outside every night, and I see pedestrian traffic that passes by me, and it's not what Mountain Road sees. This is another false and misleading statement. What I've come to find is that the planning staff will say whatever it takes to justify their position. Staff states that by forcing me to install sidewalk, they'll be able to complete gaps in the sidewalk system. Staff uses the residents to the south of me to justify the continuation of a sidewalk across the street going south. What staff does not state that 2 properties to the south of said property does not have sidewalk. If that's the case, I feel I'm being singled out to set an example of city's authority. None of this makes sense to anybody outside the planning world and the people that they advise. Other than staff has the authority to do this. The planning staff sees that this makes sense. Only the planning staff sees that this island of sidewalk makes sense. The reason I ask this question is because around the corner from me, a 2-story duplex has gone up. And if you look at the map in your packet, there's a map in your packet of sidewalk, of areas with sidewalk and so forth. On the corner of 14th and Mountain Road, you see 5 vacant lots. As of today, 4 of those lots closer to the alley have been filled with a 2-story duplex. If you look at the 5th lot next to the street, there is no sidewalk. If there were an opportunity to fill in a gap, as staff and planning director stated, this would be an ideal situation. The question is, why the city not require the owner on the 5th lot to put sidewalk in? According to the city engineer, all he has to do is send out a letter to the owner of the lot to require them to install sidewalk. The fact that there is no sidewalk there and none will be installed raises the question, why? Could it be the city engineer and planning staff would rather force a taxpayer like me with limited financial resources and no legal help to install sidewalk versus an owner like the gas company in New Mexico with a large legal staff, or staff through their arbitrary statements providing additional evidence of a poorly written ordinance? How can the planning director state that the planning department will require any changes to property status when they come before with a permit request, and yet allow a 2-story duplex in the gas company in Mexico not address the actual completion of a sidewalk system on 14th and Mountain Road? This has been the whole goal of the planning department and what they've been trying to infer upon me. And yet this one example that they have that they can complete this process, they failed to do it. This goes to show you the disparity in how the ordinance is enforced or the hypocrisy of the planning department. Staff states that they treat all applications the same. And what I would like to know, does every applicant in my position who appeals the staff decision have to require the hearing officer to tell this planning staff how to do their job? Lastly, I want to clarify for the record why I have taken the action with my property that I have. My parents purchased this property in 1947. I was born and raised on this property. In 2004, I built my house so that I could be close to care for my elderly mother. Why the city at the time did not ask me to put in sidewalk, all I can say, it may have been a flash of common sense at that point in time. So building my house so that I could be closer to my elderly mother, that's not unusual for Hispanic families. In 2009, at 93, my mother, that I moved to my house that I had built, I moved her in there because I developed a small master bedroom anticipating that day. She had become wheelchair bound, and I became her primary caregiver. I changed her diapers for 4 years as I was not going to place her in a warehouse for death, also known as nursing homes. In October 2013, she passed away. At that point, I had been unemployed for a year and a half, expending all of my savings and 2 payments away from having to be in foreclosure on both properties, even though my folks' property was paid off. I'm getting close to retirement, and I realize this is too much property for me to take care of. I could rent it out, or I could put it on a website to rent out for specific periods of time. I would prefer not to do that. I would like to move into retirement mortgage-free. Then I could actually retire. This is why I requested what I did from the planning department. I'm not some type of carpetbagger from out of state that's trying to put one over the locals and avoid as much of the city requirements as possible. I was born and raised on this property. I've seen so many changes over the years. I would love to see a sidewalk system that entails both sides of my street, that provides real safety for individuals who are wheelchair bound or in walkers, which at one point, my mom experienced both a walker and a wheelchair. Both I and my neighbor were able to get our elderly mothers to Teawood Park in a wheelchair. In conclusion, I've experienced my experience stems from a poorly written ordinance for my application that was amended in 2013. The staff failed to implement prior to my application until January 2020. This ordinance is currently being reviewed to clean up language and update again. What does that say about the current ordinance for me going forward? I'll be required to adhere to an old faulty ordinance. Additional confusion exists because of staff intentionally withholding pertinent information and making false statements about my application in the application process. More important, failing to recognize common sense because of their bureaucratic rigidity at some point in time, and the sloppiness and negative attitude towards property taxpayers by the department has to be addressed. With that, I conclude my statements.
Mr. Chavez, you haven't addressed the issues that I need to deal with in this appeal. You haven't addressed any of the substantive issues. You've only made pleas to ignore the rules because you feel that you've been judged wrongly or something, and a few other things. I know I'm oversimplifying. But
can I respond to that?
Hold on, let me finish. The standard for this appeal is whether or not, generally, whether or not the EPC erred in some way. You haven't really laid out that foundation. You have a little bit more time. I mean, would you like to do that? I mean, I'm curious what your response is to the EPC's findings, because they made a number of findings regarding this application of yours. Go ahead.
I'm sorry.
Go ahead, sir.
Can I speak? Okay.
Yes.
Yeah. No, you're correct, sir. And the reason is because I'm not a lawyer, and I'm not a professional developer. The review that you did in the previous appeal hearing was the only third-party review that I had available to me to determine whether they were correct in their assessment or not. Based on the first appeal hearing, it was evident that they did a very sloppy and poor job of processing my application, and you pointed that out. And you basically told them,
I did not, Mr. Chavez. I did not point that out. I pointed out that.
Let me rephrase that.
Let me finish. I pointed out that the EPC failed to make findings to support its decision. I didn't say anything about whether or not it acted in a sloppy fashion or sloppy manner to arrive at its decision. It just didn't make findings. That happens every now and then. It doesn't happen very often. And then when I remanded it back to the EPC, when I was reading the IDO, I noticed that there's an issue that should be resolved regarding whether or not this is a non-conforming site condition, essentially, under the IDO, because of the facts that were at issue. And so I thought it would be wise for the EPC to address this non-conforming issue in its remand hearing. So let's stick to the facts, sir.
So with that being said, I'm relying on your review to determine whether they were accurate in their assessment or not, because at this point in time, I can't trust them. And so I have to rely on your judgment as to whether they've complied with what you've asked and whether they're correct. And I'll be very honest with you, Mr. Chavez. That's why I requested this appeal. Again, I'm not an attorney. I don't have the expertise to review what they've stated. I'm a taxpayer, I'm a layperson, and I was hoping that your review would be impartial, unbiased, and you would provide the answer as to whether they did what they were supposed to do. And that's my response.
Thank you, sir. Okay, Ms. Gould? Ms. Gould? Hello?
Yes, this is Maggie Gould. Yes, Mr. Chavez?
Yeah, I swore you in. So are you going to rebut any of the, and I'm not worried about the ad hominem attacks. Those aren't really significant to me in judging this appeal. I did review your report to the EPC, and thank you for that. You laid it out very carefully, step by step, for somebody who's slow like me. So I appreciate that. Is there anything you'd like to add to the analysis?
The only thing that I would go back to is the original remand instructions to the EPC were basically three. There were three main issues. There was the provision of substantive findings, which the EPC approved, and those are part of the record and you've reviewed. The EPC was then also asked to determine whether or not the DRB had the authority to require the applicant to construct sidewalks. I feel there's a robust discussion of that in the record, and that was addressed. And then the discussion regarding are the sidewalks a non-conforming site feature, and I feel that we've cited sections of the IDO as well as the sidewalk ordinance to support that. So if you have additional questions about the record or the process, I am happy to address those. We also have Russell Brito, the current planning manager, has joined us in the meeting, and he is available as well for EPC questions.
I thought Mr. Brito retired.
I believe we have another month left, and then yes.
Wonderful. It's certainly up to you. I'm not sure I have questions. I think the record is very good now. We have a good record. Perhaps with I noted that you made a contrasting argument between a non-conforming site feature or site condition under the IDO with non-compliance to meeting the standards in the ordinances. Using the fact that Mr. Chavez, he stipulated in this hearing, and I assume he stipulated earlier, that he constructed a home in 2004 on this property. He says he wasn't required to improve the area with sidewalks. Whether or not that's an important distinction, it seems to me it's beside the point whether or not he was required to or not, because the ordinance requires it, and it required it in 2004. Is that correct?
That is my understanding, yes.
Okay. So, and I note that there's a map on page 41 of the record. Is it page 41 of the record? Page 40 of the record, which Mr. Chavez cited to. And I'm looking at it now, and it shows the existing sidewalks in the area. Can you refresh my memory what the standard is for determining whether sidewalks are necessary based on what's existing in the area?
So, Mr. Chavez, this is probably a better question for Matt Grush, who is our traffic engineer.
Okay.
The sidewalks are required by ordinance. Perimeter sidewalks are required for residential properties, but it's generally the transportation staff that reviews the specifics about those sidewalks.
Okay, so Mr. Grush, are you there?
Yes, I am. I'll turn my video on. Yes, good morning, Mr. Chavez.
Good morning. Let me swear you in, sir. Can you please raise your right hand? Did I already swear you in, or I haven't?
No, you did not.
Okay, thank you. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
Yes.
Thank you, sir. Did you understand my question?
Could you repeat the question?
Sure. And I did review this record, but it was a few days ago. The analysis to determine, I thought there was an exception in the sidewalk ordinance that compared the existing condition of sidewalks with what is required. For example, if there is a majority of the area surrounded by sidewalks, then you don't get the exception. If a majority of the area is not surrounded by sidewalks, there's an exception that allows for the lack of sidewalks to continue. What is the standard for that again? I don't want to look it up real quickly, and I was just wondering what that is.
I'm not aware of the measurement or the metrics for the requirement for sidewalk or not, but in the variance application section, there's a discussion on the intensity of the use. And this area kind of meets those requirements, and there's pedestrians present, there's residents present, there's potential for people to be using a sidewalk. So based on that, I would think that this is a location that a sidewalk would be required.
Okay. So that partially answers my question. I'll look for that standard. I thought I reviewed a standard it was either in the IDO or the DPM regarding whether or not the area was surrounded with I don't know, I don't think the term majority, but whether or not it was substantially surrounded by sidewalks or something to that effect. But I'll look at that again, unless somebody can answer that for me now.
So, Mr. Chavez, are you trying to? This is Maggie Gould. I'm sorry. Are you asking about the sidewalk ordinance itself, or are you asking about the waiver and variance criteria?
No, it might have been in the waiver and variance criteria. You're right. So yeah.
Because there is language in the waiver and variance criteria, and again, depending on whether we're looking at the IDO standard or the DPM standard, but there is language about we do DPM waivers to sidewalk width, so that if the new requirement is a 4-foot sidewalk and you have a 3-foot sidewalk and everybody else has a 3-foot sidewalk, you can ask for a width waiver so that you match. You can also ask for, you can also cite kind of historical criteria. We've had waivers, especially like in the North Valley where there were no sidewalks anywhere, where that it sounds like that's the criteria that you're speaking of.
Okay, and so the criteria, what is it? Substantially, there's the area substantially lacks sidewalks, or I mean, what?
Yeah.
Look at that term that's used. I can find it, I suppose.
Okay. Yeah, but it's what you just said, that there are no existing sidewalks, and so it isn't that there are some sidewalks, or that it's an area where we want to, in this area, transportation determined that there is a public benefit to adding these sidewalks. The places where I think we have done the waiver to allow no sidewalk at all are like in the more rural parts of the North Valley, where you have a very tiny existing street and you don't have the right of way to put in a sidewalk. And like, I know we did a couple on stub streets, so there isn't connectivity there.
And I know that the EPC specifically found in its findings that the majority there has sidewalks. I think it was finding 14, 15, something like that. So is there anything else that you would like to add? I don't have any more specific. Oh, I do have one more question, Ms. Gould. Is this appeal, does this appeal relate to the waiver or variance or both? Or is it just, does it relate to the building permit, which requires sidewalks, or all three?
So in this case, there's not, this particular case doesn't have a building permit, it has a platting action.
Right.
And so those improvements are tied to the platting action.
Okay, so my question is does this appeal relate to a variance request or a waiver request? Mr. Chavez seemed to muddle that line, claiming that he didn't apply for a waiver. And so I'm wondering, what is this appeal? Does this appeal relate to the actual platting and the requirement of a sidewalk, or does it relate to a decision on the variance?
Right, so the city council made a change to clarify the workings of the DRB. And part of that change was to clarify that actions, if you wanted to change the way that you were applying the IDO, the DRB will call that a waiver. And so this is, the applicant is asking to waive the sidewalk requirement.
Got it.
And that was what the DRB denied.
Right, because under resolution, I think it was 35 or 30.
I would have to specifically look up that number.
Right.
But rather than a variance to the width of the sidewalk, the applicant was asking for a waiver to the entire provision of the sidewalk. Okay. And that language, because of that change, and because and Mr. Chavez is correct that staff did not implement that change in a timely manner, the words variance and waiver were used interchangeably. But I feel that we've clarified the waiver issue at this point.
So the appeal is regarding the waiver decision as well as the decision requiring sidewalks, correct? Mr. Chavez?
Yes, that is correct. And I also have a question when you have an opportunity.
Okay, we'll get to that in just a second. Thank you so much, Mr. Chavez, for your patience. Ms. Gould, do you have anything?
And Mr. Chavez, let me go back and clarify the again, because of that move, and this is part of the issue with this, that what the applicant is asking is to the lack of sidewalks, and we do have the IDO perimeter sidewalk. What transportation is specifically looking at are the criteria in Chapter 12 of the DPM, and because it's the DPM, not the IDO, it is that variance.
Okay, thank you. Anything else, Ms. Gould?
I believe that's it, but I will be happy to try to answer any questions. And Mr. Brito is also available if you have any EPC specific questions.
I do not have any EPC specific questions. I'm glad the EPC made findings. It looks like they made quite a few factual findings. So I appreciate that. Mr. Chavez, this is your time to make a rebuttal argument. You may ask me questions. I may not answer your questions because this isn't really a place for me to answer questions for you.
Thank you.
But you can cross-examine Ms. Gould, which means you can ask her questions. Are you prepared to do that? Do you want to use that time? You can cross-examine Ms. Gould, and I can give you additional time for your rebuttal argument. What would you like to do?
I would just like to ask one question of Ms. Gould, and that is the confusion that was created with the language between waiver and variance. Why was that never clarified to me, and why was there never any documentation as to why my application was no longer valid as a waiver? I understand what the city council did prior to my application, and the confusion that it created for me continues to today. And so why was I not provided clarification as to why the staff took so long to make those changes and how it impacted my specific application?
Okay, so I think we've discussed that to some extent, but The changes that were the DRB changes that were made were kind of a substantial list of things, and we did lose that process in there. I think the other thing is that both the variance process and the waiver process, as we've said in the record, are substantially similar. So it wasn't that your application was no longer valid. We carried your application, the same application, through the process with some additions. And I know that I sent you some emails. I believe that Jolene Wolfley spoke with you about the process. And I believe that transportation staff also spoke with you. And if those aren't true, please correct me. But I know that we tried, and I'm sorry that was not clear for you. And I'm not sure what else we could have done to clarify that. But you know, and again, I'm sorry that this process is confusing, and I understand that it is, especially for somebody coming from, you know, not coming from a planning or development background. So that's, I guess I'm sort of slightly unclear as to what you're asking, because I do feel like we tried to address that.
So in your attempt to address those issues with me, what I recall was that you folks were trying to encourage me to apply for a variance, and that you were trying to discourage me from continuing with a waiver. That's how I understood the discussion, because basically I was being told that a waiver would not be approved.
Mr. Chavez, is that a question for Ms. Gould? This isn't a time to argue and debate.
No, she stated that.
Let me finish, sir. Let me finish, please.
Sir, yes.
So you don't get to debate with the answers. If you ask a question, you're stuck with the answer, whether you like it or not, whether you agree with the answer or not, you're stuck with it. Now, if you'd like to ask another question, certainly if you want to turn your statement into a question, you can ask that question, but please don't debate with Ms. Gould, okay? This isn't the place for that. I'd appreciate it. Thank you so much. And you can continue, sir.
My intention was not to debate. She asked me if that was true statement that she had stated. And what I recall was what I stated. I have another question. With me having to put in a sidewalk on 15th Street that is going to literally end in front of an elm tree, what are my options going forward?
Ms. Gould, can you answer
my
that?
understanding, and sorry, go ahead, Mr. Chavez, Mr. Stephen Chavez.
I'm going to let you decide whether you want to answer that question, because I don't think it's a relevant question for this hearing. But certainly, if you want to help Mr. Chavez out with the answer to that, you can.
The only thing that I can say to that is what my transportation colleagues have already said, which is those transitions can be tapered and structured in a way to make that work. And I am not an engineer, so I'm not the best person to speak to that.
That's an engineering.
Thank you.
Correct. Ms. Gould, that's an engineering issue, correct? But it can
yes, Mr. Chavez, the technical details of the sidewalk are an engineering detail, are an engineering, yes.
Okay, thank you. Mr. Chavez?
Well, I thank you, and thank you for your patience with me, because as noted, I'm not an attorney, I'm not a professional developer, so these hearings are a little difficult, and so I just appreciate your patience with me.
Understood, sir. Thank you. Anything else, Mr. Chavez? You can make an argument now if you would like, a closing argument. You have that time.
Thank you, sir. Again, you know, I would just like to reiterate, I understand that there's technical aspects to this process, but there's also common sense. And I realize that that's really difficult when you have specific ordinances and citations that you have to adhere to. But the fact is, there's no sidewalk on my block on both sides of the street. And what you're creating for me is a serious legal liability. And you're also putting individuals in wheelchairs and walkers in a dangerous and precarious situation. So, you know, maybe those don't address your specific criteria, but in the world of common sense, I don't understand why I'm being forced to put in sidewalk that creates a dangerous situation and creates a legal liability for me. And really, that's really all I have to say at this point in time. I do want to see sidewalk in my neighborhood, but I'd like to see it on both sides of the street. I'd like to see it for the entire block. And at this point in time, the city has no plan to complete that system on my block. The neighbors are not going to voluntarily put in sidewalk. The sidewalk that is shown at the end of 15th Street on Mountain Road on the east corner, that's not sidewalk. That's a driveway pad. So that's not even marked correctly. So this is more of an emotional plea. I understand the legal requirements, and I'm probably going to lose this battle. But I really find it amazing that as a planning department, that it's not your responsibility to plan for new sidewalks. There's a $400 million gap in the sidewalk, and there's no plan for that other than this whack-a-mole ordinance that, you know, as property taxpayers come before us, that's when we nail them. And I find it amazing that the city has a 1% dedicated to the arts, but the planning department can't come up with a recommendation to the other departments with a dedicated amount to begin to repair sidewalks throughout our city. So when the planning department says that's not our responsibility, I find that absolutely amazing, because as a city department, it's your responsibility to cooperate and collaborate with other departments to address problems that you are dealing with on a daily basis. So with that, I conclude my comments.
Okay, Mr. Chavez, I have more questions as a result of your closing argument, because you raised an issue, a substantive issue that wasn't raised earlier, and it wasn't raised in your written arguments. You claimed that the map, the legend and the map are incorrect on page 40 of the record. That's an important map for this appeal. You claimed that on 15th Street and Mountain, I don't know which side, but
it's the east side.
East side, okay, at 15th and Mountain, you claim that those are not sidewalks. Those are, that is a driveway to some effect. I'd like for Ms. Gould or Mr. Grush to testify on that, because I need to know whether or not there are disputed facts regarding this appeal, substantive disputed facts. You're claiming there are. Mr. Grush, thank you, and I'm sorry I'm opening this back up. Could you testify and tell me whether or not Mr. Chavez is correct or incorrect?
I'm currently looking at a Google Earth image at that area, and that is a sidewalk that is crossing a drive pad. That's how our drive pads are constructed. There's a sidewalk with a taper. It probably doesn't comply with the cross slope of current ADA requirements, but it is built as a sidewalk. That was the purpose for that.
And by ADA requirements, you mean because of the slope? The slope doesn't meet the ADA requirements.
Correct. It appears that way in the image I'm looking at. And on the west side, there's also a sidewalk, and that one looks to be a normal type of sidewalk.
Okay. And because I'm looking at the map, do you have the map in the record that distinguishes the existing sidewalks and the lack of sidewalks around?
Yes.
Okay, so I'm looking at page 40 of the record, and on the east side it shows those green squares which represent sidewalks. So that representation is correct in your opinion?
Yes, for this type of graphic, it would be close enough to say that's an accurate representation.
Can you explain what that means to me? For this type of graphic, that would be correct.
Oh, it's not a precise engineering drawing showing exact dimensions. This is to represent something so someone can understand the general concept.
Okay, thank you. Ms. Gould, did you develop this map?
This was developed by one of our other planners using, I believe, GIS data and field checking it with Google Earth in the way that Mr. Grush just did.
Okay. And what is your opinion regarding Mr. Chavez's claim that on the east side of 15th and Mountain, there are no sidewalks at the corner?
So
Are you asking?
I'm asking Ms. Gould. I've asked you the question already, and,
right.
and I'm asking because the map represents that there are sidewalks at that
So I'm looking at the graphic under the map. The map is overlaid on an aerial photo, and based on that, to me, it looks like there is a sidewalk at that corner.
Okay, thank you. And Mr. Chavez, I'm going to allow you some time to cross-examine the testimony of Mr. Grush and Ms. Gould regarding this issue only. Do you have any questions for them regarding this issue only?
Well, it appears to me that they're not sure. It appears, and the statement was, it appears that there's. I live there. I walk there. It's an extended driveway pad for that business there. There's a step up to the curb, but that's all there is. So to say that is sidewalk, I would ask that you take a look at that yourself, Mr. Chavez.
I can't do that. I can only look at what's in the record. But it appears you have no questions for Ms. Gould or Mr. Grush, and you just wanted to supplement your argument, and that's okay. So we're going to close this now. Mr. Chavez, anything else other than what you've already said?
No, sir. Again, I just want to thank you for your patience.
Thank you. Thank you for your patience. Thank you, Ms. Gould. Thank you, Mr. Grush. Thank you, Ms. Sanchez and Mr. Varela. And thank you, our court reporter, and Mr. Biazar. And thank you so much, Julian, for all your help. I know I'm giving out a lot of thanks, but it's been a good week for me. So anyway, good luck, folks. I will have a decision out very quickly with this matter, or not a decision, a recommendation to the city council. Okay?
Thank you, sir.
Let's go off the record. Bye-bye.
Thank you.
Thank you, guys.
Thank you.